Hello everyone, this is Mahek, Upadhayay, Legal Internet LEXIS and Company. Welcome back to our channel. In this video, I'll be discussing about vested interest and contingent interest. I'll be starting with vested interest. Vested interest mean the interest a interest created if a interest created by a transfer of property against a person is to be applicable forthwith just after the deed has been executed, and there is no condition for future events. There is no time prescribed in the event. If the deed is, it will be considered as a vested interest. A vested interest is generally an interest that is created soon after a deed has been registered and executed, and the transfer of a property is completed. This vested interest this vested interest does not depend upon a future event. However, there shall be a condition of clause that the interest would be transferred only if the so and so condition would be satisfied, but that condition would be a certain condition and would be and would and would become and would be and such condition would occur at one time. It's not an uncertain event whose happening or not happening is uncertain. So when a clause does not talk about any uncertainty and it's very clear about the interest created without any limitation to the time, without any reference to any future date or future condition, it is referred to as vested interest. Vested interest, as I said, is created soon after the deed is created. So an interest that is created in the favor of a unborn child is also a vested interest. Although the possession of the property could be held after a particular time, but that doesn't mean that there is no interest created. Possession is different thing, and creating an interest, the right of ownership, is created as soon as the deed is executed. That is the vested interest. Now the nature of this vested interest is transferable and hierarchical. Means if the transferee died before taking the possession of the property, against his interest has been created, then his invested interest in that property would be inherited by his heirs. That interest would not be vanished with the death of the transferee. It is transferable, right? And now let's talk about contingent interest. Contingent interest is very clear if it depends upon the happening or not happening of a future event. For example, if A executed a deed and saying that it would only occur if she would marry my daughter, and suddenly so the deed would be so the interest would be created only if she would marry his daughter, and if she would have married someone in the meantime, then no interest could be created by the deed, and that deed would be considered as void. Since it's not no interest is created soon after this execution of the deed, so the contingent contract died. So the contingent contract vanished or becomes void soon with the death of one of the transferee. Now I'll be talking about the difference between the two. Difference is very clear. First, one vested interest is transferable, while transferable and hierarchical. However, contingent interest is only transferable. It cannot be higher. Its heirs cannot inherit the property unless the contingent interest has not been converted into vested interest. And when it is converted into vested interest, once the conditions are mentioned in the clause of the contract or the deed has happened or has occurred. And in vested interest, the interest in the right of ownership is created as soon as the deed is executed. May the possession may be after some particular time. Contingent interest, the interest would be created only when the condition has occurred. Death of the transfer does not affect the nature of the vested interest. It is inherited, it's hires, while contingent interest died with the transfer death of any of the parties involved, and if same has not been converted into vested interest. This was all about vested and contingent interest. Hope you like this video. Thank you.